Hey, Scott Radigan here at Functional Lawyer, and this week we're bringing you 7 legal errors that practices make when handling medical records, usually surrounding HIPAA. So all the time I get HIPAA questions, and there's just a ton of misinformation out there. These are the top 7 that I see. So let's jump right into it. One is that a non-custodial parent does not have rights to access their child's records. And that is false. Unless there's a state-specific law that says otherwise, just because the custody issues have been split in a way that has one person have primary custody and one have less custody, that doesn't take away that parent's rights to the records. So unless there is a court order showing otherwise, both parents have the right to access their child's medical records. Number 2, physicians don't have to provide patients access to their entire medical record. That's also untrue with a couple of exceptions. So you do have to provide almost all of the complete record to patients, including progress notes on request. A couple of exceptions are if there is a mental health note in there that might be subject to a little bit extra withholding from the patient, and check, if you're a mental health counselor, you will know what those are. Or otherwise, if there's information in there that might be harmful to the patient or to others, if you disclose that to the patient. But always check and make sure, ask your attorney before you exclude something from somebody's records. Number 3, and this is one of the biggest ones, most practices that are new to it, that are opening up brand new practices, think that the notice of privacy practices that you give to a patient when they first come in is your HIPAA obligation 100%. And that's not true. There are 3 parts to HIPAA: the privacy rule, which gets most of the attention, the security rule, which is just as important, and then high tech, which deals with a lot more of the technical internet side of things around HIPAA and was passed in 2013. So if you don't know what you're doing, I suggest you find at the very least, HIPAA policies and procedures manual. We have them at Functional Lawyer, or find a HIPAA specialty group that will help you, or talk to your attorney on your obligations under HIPAA. Number 4, some physicians think they're not required to provide patients a copy of their medical records directly, that they have to forward them to a third party. That's not true. You have to give people access to their records. Today, it's easier than ever. You just say, log into the portal and your records are right there. So that shouldn't be an issue anymore, although that myth is still out there, along with the rest of these. Number 5, physicians think that they can charge a flat fee in order to make copies or otherwise deliver the records to the patient. Again, not as big of an issue. There's no flat fee authorized under HIPAA. And in fact, the fees that you can charge are somewhat technical. I mean, you can't charge $25 for records. You can charge for the labor involved, only for the part of copying records. You can charge for the CD or the USB drive if they request it that way. But there's no flat rate like $25 for their records. Number 6, record requests can be honored without a patient's signature. That can be true in some situations where, especially if you're looking for payment, or if you're going to share the records with another physician for the purposes of treatment. But generally, it's a good idea, even if not required, to get a signature when there is a records request at your doorstep. And then number 7, records requests can be dishonored or refused if a patient owes money to the practice. That's not true either, and that gets a lot of people into trouble. In fact, that's one of the emphases of the Office of Civil Rights, which enforces HIPAA, that getting people their records in a timely manner, no less than 30 days, and that's the upper limit. It ought to be a lot sooner than that, is the standard under HIPAA, whether or not they owe money to the practice. So you definitely don't want that to be the reason why you avoid you don't want to have have someone owing you $300 lead to a HIPAA violation of $5,000, something like that. So just give them the records and then try to collect the payment as you otherwise would. Now, records requests are, again, an emphasis of OCR. And so these are big myths that ought to be rectified. Hopefully that's brought to you some clarification on at least one of these. If you aren't sure what you're doing, if you, like many people, are now the HIPAA security officer and the privacy officer in your practice for the very first time, I suggest you get some help with it if you don't know, because this is one of the things that are a big red flag and can lead to hefty fines down the road. As always, if you have any questions, you can always reach out to me at Functional Lawyer. If you're watching this on YouTube, please consider subscribing. It really helps out the channel, and we'll see you guys next time.